Tully Rinckey PLLC thanks the Blacks in Government Executive Committee for allowing the firm to present this free webinar to Blacks in Government members. The firm supports the goals and objectives of Blacks in Government, and we're pleased to be of service to you. Through our partnership, Blacks in Government members are entitled to 2 free half-hour phone consults per year regarding federal employment, security clearance, or military matters. Members pursuing claims receive a 10% discount on legal fees. Call us at 1-888-529-4543 or email info@fedattorney.com to learn more about our partnership with Blacks in Government and schedule your free consultation. As former chairman of the U.S. Merit Systems Protection Board, Eeo McPhee brings a high level of authority and experience to Tully Rinckey PLLC's Federal Employment Law Practice Group. In over 30 years of public service, Eeo has led 2 government organizations and managed multi-million-dollar budgets, in addition to serving as a litigator, adjudicator, employment and personnel lawyer, and human capital strategic advocate. Eeo draws upon his experience to effectively represent federal employees and personnel in a wide range of employment and labor issues, including discrimination, sexual harassment, equal pay, adverse action, and Inspector General investigations. Tully Rinckey PLLC is one of the nation's largest federal sector labor and employment and military law firms. We're a full-service firm for federal and government employees with legal issues. Our attorneys together have about 130 years of experience practicing federal employment law. They are key components of a team whose targeted, aggressive legal approach has secured positive results for clients in virtually every aspect of federal employment and labor law. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. Now, I'll turn the floor over to Eeo McPhee.
Good evening, everyone. I'm Eeo McPhee, and I'm happy to be here to talk to you. We have a lot to say and a little time to say it in, so let's get going, okay? Today we're going to talk about prohibitions against discrimination in a general sense, and then we're going to focus a whole lot on hostile work environment, what it means and how you go about proving it. Everybody I talk to say, I'm in a hostile work environment. Hopefully by the end of this session, you would have the capability of better assessing where you are, okay? Let's start from the beginning. By that I mean Title VII of the Civil Rights Act of 1964 as amended. That's the statute that says it's an unlawful employment practice for an employer to discriminate on the basis of race, sex, age, national origin, religion, and disability in hiring decisions, and also in compensation, terms and conditions of employment. Okay? The phrase terms and conditions of employment includes requiring people to work in a discriminatory, hostile, or abusive environment. Now, obviously, what is a hostile environment, hostile work environment? Let's start exploring that. In order to show an unlawful hostile work environment under Title VII of the Civil Rights Act of 1964, the employee must demonstrate, 1, that he or she is a member of a protected class. That's not difficult to do. That he or she was subject to unwelcome harassment. Remember, unwelcome harassment, okay? And we'll talk a little bit more about that as we proceed. And 3, that the harassment occurred because of the employee's protected class, okay? Moving on. 4, that the harassment affected a term, condition, or privilege of employment, and that the employer knew or should have known of the harassment and failed to act in a reasonable manner to prevent it. That, as an aside, if the harasser is a supervisor, then the law presumes that the employer knew, since the supervisor is a part of management. If the harassment is from a coworker, there's no presumption that the employer knows. So what do? You've got to make sure they know by complaining. And there is a mechanism in every agency to do so. And another point is that there's no, and this is very important, there is no actionable hostile work environment under Title VII if the employee fails to meet one or more of the above criteria. Remember, you've got to establish all 5 criteria, not 1 or 2, but all 5. Okay? Now, let's talk about the kind of harassment that affects the term, condition, or privilege of employment. To satisfy the 4th element, the employee must generally show that the harassment was severe or pervasive. Okay? Courts would look to the frequency of the harassing conduct, its severity, whether it was threatening and humiliating or was merely offensive, and whether it unreasonably interfered with the employee's work performance. The harassing conduct must be connected. In other words, it has to be like or related, so you could put together one or more harassing events to prove that the harassment was pervasive. Okay? The conduct must be sufficiently extreme. Now, if it is extreme, and some of these examples will bear it out. For example, the first one talks about Smith versus Sheehan. Okay? A single instance of a physical assault can create a hostile work environment. You don't need multiple assaults. Okay? In that case, this supervisor was amazing. He called the plaintiff a name. He threatened to F her up, pinned her against a wall, drawing blood. Clearly, that had all kinds of elements of abuse, charges that could be brought in criminal court against this particular supervisor. That clearly was extreme. You didn't need a second event. Okay? In this other case, in Winston versus Clough, the hostile work environment claim supported where the plaintiff alleged he faced unsubstantiated allegations. Okay? Remember, the key here is that those allegations that they allege against this individual was never proven. Had they been proven, you get a different outcome. But the allegation was unsubstantiated that the employee had threatened violence against a co-worker. This employee was evicted from his workplace and barred from meeting, stripped of supervisory duties, and banished to a cramped working space. On top of which, he was facing a proposed suspension that was later overruled. As I said, had those allegations been true, then you would have had a different outcome. Holmes versus Martin is another case. Where the D.C. District Court held that they found plausible a claim of hostile work environment where the plaintiff was subjected to public ridicule, isolation, and harmful treatment so severe it caused psychological illness. Now, had there been no showing of psychological illness, this plaintiff would have had a harder job in showing that his working conditions were altered in such a way that caused him harm. Okay. What is not harassment that affects a term, condition, or privilege of employment? Courts generally consider a simple teasing, offhand comments, and isolated incidents as not altering the terms and conditions of employment. Examples include telling a person from Trinidad to go back where she came from, to shut up. She should never have been hired and assigned to various clerical duties. The D.C. Circuit Court held that was not hostile work environment. Also, I don't know and I don't recall offhand what the protected activity was. In other words, was this person alleging age or race or sex or whatnot? But in any event, evidence in the context of the allegation was not sufficient to prove a hostile work environment. An Indian employee suffered the same kind of outcome. There, she alleged a hostile work environment based on race when a supervisor was constantly hostile and hypercritical and kept the plaintiff out of important meetings and interrupted the flow of her work to interpose critical editing and credited all complaints against her. That wasn't sufficient. In the next case, Bevin versus Hilton Hotels Corporation, the reason for the hostile work environment must be because of membership in a protected class. Evidence that the hostile work environment was based on some other issue like unprotected complaints about workplace security resulted in no valid claim for hostile work environment harassment under Title VII. These kinds of cases, despite your best efforts, would end up with a grant of summary judgment for the agency. Okay. Now, let's look at what kind of evidence that you need to support a hostile work environment case. Yeah, there are more than one ways in which you can establish that. Obviously, you got to show that the employee is a member of a protected class. Okay, that's usually easy to identify. It could be age or sex or race or national origin, etc. However, if the work environment is based on reprisal, a lot of the cases we see are based on reprisal, then the employee must show that he or she engaged in prior protected activity, as is the case in any reprisal case. Okay, and how do you do that? You got to show that the employee either participated in an EEO case, filed a case of herself. It doesn't have to be formal, it could be informal, or oppose discriminatory activity in the workplace. I.e., is not your case, but you oppose it. Also, as we said earlier, the employee's got to show that she was subject to unwelcome harassment. Okay, and by that, the employee must provide evidence that he or she found the harassment subjectively unwelcome. In other words, the employee didn't consent to the harassment. So, when any one of you are being harassed, say something, complain, okay, and complain in writing. Evidence of subjectively unwelcome harassment include telling the harasser you don't appreciate, telling the harasser to shut up, to move away, to leave you alone, emailing or complaining to HR about the harassment, and demonstrate refusal to participate in harassment. You know, in events, say like there are lots of sexual teasing and joking and name calling, etc. You don't have to stay quiet. You know, just tell folks that you're not going to participate in that, and that's a form of opposition. That would help you prove that you are a victim of a hostile work environment. And also, you got to have some medical records showing harm as a result of the harassment. Okay. Now, of course, you could testify as to, you know, your sleepless nights and change personality and so on and so forth. But how far will that go? You need to have some doctor who's going to who has written in medical records that you had to be treated by that doctor for those events that were occurring in the workplace and that you were severely harmed. Okay? And 3, that the harassment occurred because of his or her protected class. Evidence that the harassment occurred because of a protected class can come from a variety of forms. Some of the examples could be comparative evidence. You know, that people of a different race or sex or age are treated differently under similar circumstance than you, the victim. Direct evidence. Every so often you get lucky and you could prove directly that is discrimination. And, you know, somebody may make a statement in your presence or, you know, supported by other folks that indicate a discriminatory motive for the action. You know, statements like, you know, women can't do this kind of job. Okay? And then that particular female employee is reassigned. Racial epithets, that type of thing. Then you can also prove it by circumstantial evidence. Here, you don't have direct evidence, but you're asking the court to infer from a series of related type of evidence to conclude that the true reason is got to be race or sex or age. And that comes up in a context where the employer gives a legitimate non-discriminatory reason for the action, and now the employee can show that that reason is not true, and it is really a pretext for discrimination because of the employee's protected class. And 4, that the harassment affected a term, condition, or privilege of employment. Now, this is the most difficult category of evidence in proving a hostile work environment case. Okay, the courts take a look at the totality of circumstance. And it is difficult to ascertain whether a court will view a particular situation as being objectively severe, pervasive, or extreme. Some examples of evidence an employee can use to support this category include, again, medical records, documented evidence of inability to perform various job functions because of harassment, evidence of similar conduct directed at other employees in the same protected class, and 5, that the employee knew or should have known of the harassment. This is really important. Not only the employer knew or should have known, but the employer took no steps, no reasonable steps to prevent it. In some instance, a woman complains about harassment, and instead of moving the harasser to a different job, they move the woman to a different job. Okay? At a different job, maybe a job that's dead end, certainly not a job that the victim wanted. Okay? Again, what I said earlier, if the harassing employee is a supervisor or co-worker, then different standards apply. If it's a supervisor, then knowledge is, by the agency is presumed. If it's a co-worker, you got to prove it. Also, you got to submit evidence that the employee utilized company policy, agency policy to report the harassment. Every agency has got a policy. Evidence that the employee filed a previous EEO complaint regarding the harassment. Now, how to properly file a hostile work environment claim. Okay? If you believe, and that's all you have to do, just have a reasonable belief that you are suffering a hostile work environment, then the first thing you need to do is to contact an Eeo Counselor. And for those of you, let me tell you very clearly, you got 45 days from that event that gave rise to this claim to let this Eeo Counselor know. And I would suggest you, you notify them in writing. A simple email would do. And then, of course, then that leads to an interview and so on and so forth. And during the course of that interview, you could provide the agency with any additional information that may support your claim. Okay? I would suggest this. If you believe you're suffering a hostile work environment claim, contact an EEO, an experienced employment lawyer. It's very clearly that an experienced employment lawyer, after interviewing you, could in fact beef that claim up to such a degree that the agency can't throw it out for any variety of reasons that agency like to throw out these cases, in the beginning. And, you make sure that you don't miss all of those important deadlines, 45 days being the initial one. And there are others at each step in the process, okay? Couple of examples. If the employee believes he or she is suffering a hostile work environment, the employee must contact an Eeo Counselor within 45 days, okay? And the employee must carefully construct the language of the formal complaint to make sure that the hostile work environment claim and any other potential claims are administratively exhausted. That is, remember, before you get to the formal, you go to the informal. In the informal, you've got to lay it all out there. You got to be over-inclusive, because if it ain't in the initial informal process, then the agency is going to argue that it can't be in the formal complaint itself. Okay? How can an experienced attorney help you? Well, it should be sort of fairly obvious. Counseling you in recognizing and preserving your claims. They can identify your claims. Counseling you through difficult situations is not an easy road to hoe. It's long, it's exhaustive, and it is difficult, and it will cost you money, so you are in and could be in a bad place, and you don't want to make it worse by not stepping out the best you can right out of the box. Okay? There are all kinds of exceptions and so on, and you need to figure out whether or not some of those exceptions apply in your case, and you need to figure out what evidence you have to get and what's the best way to get that evidence. And clearly, and let's face it, the employee always has less resources than the agency, so you've got to put some kind of a settlement agreement out there on the table. Remember, you hold the key to settling, okay? The attorney can't settle a case unless you approve the settlement. So you should have that frank conversation with a lawyer up front, and you should, and that lawyer can help with, try to leverage your case and facts to your benefit to get the best possible settlement out of the agency, and failing that, to preserve your claims if it has to go all the way to hearing. Okay? If you need some further information, just call us up. Thank you very much. I hope this has been beneficial to you, and I hope I or somebody from a firm could be of assistance to you, in your moments of need. Thank you.
Thank you for participating in this webinar led by former MSPB Chairman Neil McPhee. If you'd like to learn more about how to best defend your federal career, call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. As a reminder, our experienced team of national security clearance attorneys regularly assists federal employees and contractors, as well as military personnel, in all stages of the security clearance process. They've helped hundreds retain their clearances. Our military law team is nationally recognized for its ability to win cases against tough odds. Our military lawyers have proven track records of changing the military law landscape through knowledge and tenacity in all matters faced by service members, including but not limited to courts-martial, discharge upgrades, and desertion. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team.